share this plenary discussion with a representative from the Ministry of Justice and a representative from Transparency International, a leading non-governmental organization in Cambodia. I will focus my presentation today on some of the main areas affecting people's right to justice. This in line with Sustainable Development Goal number 16, which sets out the target to promote the rule of law at the national and international levels and ensure equal access to justice for all. As the development partner co-leader of the Technical Working Group on Legal and Judicial Reform, OHCHR has supported the Ministry of Justice in several areas, looking to improve judicial services and access to justice for all. In terms of court efficiency, the Ministry has undertaken important steps in cooperation with development partners to implement the law on court organization. This includes mainly the establishment of administrative secretariats in each court, the recruitment of additional personnel, and the adoption of some implementing legislation. In discussions with judges and prosecutors, we have noted that not all are yet clear on their respective roles vis-à-vis the new secretariats. Thus, OHCHR will organize several meetings this year for judges and prosecutors to discuss how to improve coordination between the administrative and adjudicative functions of each court. In terms of increasing skills and capacities of judges and prosecutors, I'm happy to announce that the first compilation of judgments will be published this year together with the Supreme Council of Magistracy. For the first time, selected judgments submitted by judges themselves will be available to the public. The publication is a positive sign of increased transparency among the judicial profession, and it should also serve as an important tool for the Royal Academy of Judicial Professions and for law faculties throughout the country. Despite these positive measures, there is concern among the public that judges cannot perform their jobs independently. Are they independent from other branches of government? Are they free from improper interference, intimidation, or harassment? The Code of Conduct for Judges and Prosecutors demands that they all abide by the principles of independence, impartiality, and integrity. Take, for instance, the procedures in place for the selection, promotion, and transfer of judges. According to international human rights standards, these should be objective, fair, and independent. This means applying objective criteria related to qualifications, integrity, ability, and efficiency, and they should be based on merit alone. While we note with regard to recruitment that there has been a stricter monitoring of the entrance exams to prevent cheating, when it comes to promotions and transfers, however, as we witnessed last week, these procedures are not clear nor transparent. Although the law on the status of judges and prosecutors lays out certain criteria for the promotion of judges, the process itself lacks transparency. There is no clarity on what procedures are in place to define who is selected for a promotion or a transfer, or if these decisions may be appealed. Regarding the disciplinary system, there is a code of ethics that all judges and prosecutors must abide by. For its part, the law on the status of judges and prosecutors established the applicable disciplinary sanctions for judges who fail to fulfill their duties. However, the procedures are not included in the law, and the body responsible for these proceedings is not truly independent or impartial. Additionally, their decisions are not public, as prescribed by international human rights standards. This lack of transparency regarding disciplinary and personnel-related actions lead many to wonder about possible acts of corruption. When present in the judiciary, corruption threatens the very essence of its independence. I'm sure my colleague will address this in a few minutes, but I wanted to highlight some of the recently published rankings related to corruption, integrity, and rule of law. In Transparency International's 2016 Global Corruption Barometer, Respondents in Cambodia indicated that 59% of judges and magistrates are involved in corruption, the highest percentage for any institution. Cambodia also ranks very high in their Corruption Perception Index, 156th out of 176 countries, with a score of only 21 over 100. Another index, the 2016 World Justice Project's Rule of Law Index, places Cambodia 112th out of 113 countries, ranking last in the region for absence of corruption in government agencies and effectiveness of the criminal justice system. And yet a third one, the Heritage Foundation's 2017 Index of Economic Freedom, Cambodia's score for government integrity dropped from 21% to 12.8% in just 1 year, while the score for judicial effectiveness was 22.1%. According to their report, corruption remains a serious obstacle to economic development and social stability in Cambodia. Although these studies are based mainly on people's perceptions, they are indicative of people's concerns and should not be taken lightly. Just yesterday, the office hosted a meeting between a representative of the National Committee for Subnational Democratic Development and community representatives from across the country. One of the issues raised was the different rates at which the courts take action, depending on whether the complaints are lodged by the communities or by companies, for instance. Whenever suspicion or evidence of acts of corruption arise, there should be effective accountability mechanisms to deal fairly and effectively with them. In line with Article 11 of the Convention Against Corruption, Cambodia should take measures to strengthen integrity and to prevent opportunities for corruption among members of the judiciary. Some of the ways this can be done is by increasing accountability for judges and prosecutors and removing the opportunities they may have to exchange favors and to apply subjective criteria in the administration of justice. This brings me to some of the gaps identified by OHCHR through its monitoring and capacity building activities in ensuring fair trial rights to all those who face the criminal justice system. One example is the need for judges and prosecutors to strengthen the consideration of evidence during all stages of the criminal procedure. Evidence put before a judge should be thoroughly assessed, with the overall result sufficiently convincing to support a verdict. Nevertheless, we have monitored trials where the accused have been indicted or convicted based solely on Facebook postings or on private conversations wiretapped in conditions that remain legally unclear, which make us wonder, is this enough evidence of incitement to commit violence, or is it thwarting freedom of expression? In this sense, the European Court of Human Rights has been clear in that provocative or even hostile language does not necessarily amount to incitement to violence. In order to assess whether certain language is in fact inciting to violence, a court should examine the following elements: the context, the content, the speaker, the speaker's intent, the extent and magnitude of the expression, and the likelihood of the advocated action occurring. During her last visit to Cambodia, the Special Rapporteur on the Human Rights Situation in Cambodia, Professor Rona Smith, strongly urged the Ministry of Justice to consider drafting guidelines on the evidentiary requirements and to ensure all judges are fully trained thereon. Training on legal reasoning and evidentiary analysis was included in the 2017-2018 Joint Monitoring Indicators and Activities approved by the Technical Working Group on Legal and Judicial Reform. In this regard, OHCHR hopes to work with all relevant authorities to produce a manual on the use of evidence in all stages of the criminal procedure. The best practices of the ECCC will serve as an invaluable guidance during this process. Another area that requires strengthening the capacities of judges and clerks is on legal reasoning. The new pretrial detention form in 2013 introduced the requirement for legal reasoning for pretrial detentions. through monitoring of the use of the pretrial detention form carried out jointly by OHCHR and the Ministry of Justice in 2015 and 2016, we have witnessed an increased knowledge and use of the form among judges. In some cases, the form is adequately used, including sound legal reasoning and a clear duration of detention, without automatically resorting to the maximum period allowed by law. However, some judges have indicated that the reasoning was sometimes irrelevant, as judges believed there was no need to justify pretrial detention, that there was pressure from the judicial police to send people to pretrial detention, that using the form was time-consuming, and that it would limit their judicial discretion, and in some cases, that they did not have the skills to provide the legal reasoning. We also received some requests from judges for training on how to provide legal reasoning. Because we acknowledge that having judgments with sound legal reasoning would be a decisive step in strengthening the delivery of justice in Cambodia, we will continue working with the Ministry of Justice and the Supreme Council of Magistracy this year to support trainings to judges both in Phnom Penh and in the provinces. If judgments contain legal reasoning that is both clear and persuasive, they will serve to increase the credibility of the judiciary and maximize the impact of its decisions. Finally, as mentioned earlier, OHCHR has established good cooperation with the Ministry of Justice through the Technical Working Group. The recently adopted joint monitoring indicators provide guidance on the urgent tasks at hand. Among others, these include an increased budget for the ministry, which we hope will lead to an increased allocation of funds for legal aid. The ministry has increased its contribution in the past few years, but at $100,000 for the whole country, it still falls short for the current needs. And the majority of the burden of legal aid is borne by legal aid NGOs that play a crucial role in Cambodia. The adoption of a legal aid policy would serve as an important safeguard that contributes to ensuring the fairness and public trust in the administration of justice. Another activity foreseen as part of the Technical Working Group is the elaboration of draft laws on the lawmaking procedure, notaries, bailiffs, and clerks. We hope that the drafting processes are carried out through transparent and consultative processes, and that such processes will become the standard under the future law on the lawmaking procedure. We stand ready to continue supporting the Ministry of Justice and other partners in strengthening the justice system to ensure justice for all. Thank you.